Good morning. Are you dealing with Wilkinson?
Yes, ma'am.
Let's see. Mr. Wilkinson, this is your initial appearance in cause number 25 DCCR 0260. You're charged with deadly conduct, discharging a firearm from September 13th of 2024. And since you've made bond in your case, have you had an opportunity to hire a lawyer?
No, ma'am, not just yet. No, I was going to ask if I could have a little bit more time in order to come up with more funds to hire an attorney.
So what I'll do is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, if you'll step in front of the clerk, she'll give you your reset notice. Good morning. Are you Drayden Rose? And Mr. Rose, this is your initial appearance in cause number 25 DCCR 0789. You're charged with the 3rd-degree felony offense of assault of a security officer from April 16th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I'm in the court.
How old are you?
18.
Are you still in school?
I got my GED.
You got your GED?
Yes,
So are you working?
I'm finding a job.
So you don't just get a court-appointed attorney. So what I'm going to do, since you made bond, I'm going to reset your case for about 30 days and do a couple things. One, you need to try to get a job first. If you get a job, bring me that information on where you're working, some kind of pay stub or just something that shows where you're working. I also want you to apply for at least 5 jobs a week. And if you don't have a job, you need to bring me where you've applied. So if you're print something out or copy something from where you've gone. And then in addition to all of that, I want you to start talking to attorneys, okay? You need to talk to at least 3. They all charge different amounts. They have different payment plans. I want you to start talking to them so that when you get a job, you can see maybe what you can afford or what you can't. If you do all that and you still can't afford an attorney, then we'll talk at the appropriate time about a court appointed. If you don't do those things that I asked you to do, then when you come back, you run the risk of me raising your bond and you would have to go back to jail for not following that court order. Do you understand all of that? All right, if you'll step in front of the clerk, she'll give you a reset notice. Good morning. You're Lance Charbino?
Yes, ma'am.
And Mr. Charbino, did you get someone hired?
I did not hire him yet. It's Cody Crenshaw.
Corey?
Well, Corey is Cody Crenshaw. He asked for $4,000 down.
Okay.
And as soon as I get that, which should be about 3 weeks from now.
Okay.
And I'll be able to get him hired for.
All right. You've been here a few times, so I'm going to reset you one more time. You need to get him or someone else hired before that next court date. Again, just bring that reset notice to him. He'll tell you what to do. If it's not going to work out with Mr. Crenshaw for some reason, then talk to at least 3 others. Bring me those names. All right. Step in front of the clerk. She'll give you a reset notice. Good morning. You're Presley Viltz. Did you get someone hired, Mr. Viltz? No. Who'd you talk to? Okay, did you write down the names? Well, no, I mean, I tell you the same thing I tell everybody. Bring me back the names of the people you talk to so that I know you've tried, and then we'll discuss your options. Same words I've said for 11 years to every single person in here, so no one can ever say that I didn't say them.
Yes, ma'am.
So what part of bring me back the names of who you've talked to did you not understand?
I understood. I just forgot.
You just forgot. Okay, so you're in felony court. You don't just forget. Because if you don't do what I asked you to, then I can put you in jail right now. I'm trying not to do that. I want you to follow the rules. It's not that hard. You have 30 days. Talk to 3 lawyers. Try to hire them.
I did.
Did you talk to 3?
Yes, I really talked to
You really talked to. So when you first answered, you said you talked to 2. So be careful what you're saying. All right? And you're probably nervous right now, and I get that, but be careful what you're saying because you're saying some different things. I'm going to reset your case for 2 weeks. You need to talk to 3 lawyers. You need to bring me those names of who you talked to when you come back. If you've hired one of them by then, great. If not, I want you talking to at least 3. Don't wait till the last minute because they're in court and they have things to do. So start calling today, talk to those attorneys, bring me back who they are, how much they charge, let me know about where you're working, bring a pay stub when you come back. The more information you bring me, the better things are going to go. Does that make sense? Good morning, you're Caitlin Talmore?
Yes, ma'am.
And Ms. Talmore, this is your initial appearance in cause number 25, DCCR 0595. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle, and that is from April 4th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Right. So what happens is when you're in custody in jail, we automatically give you a court-appointed attorney. Now that you've made bond, I'm going to expect you to at least try to hire your own. So what I'll do is reset your case for about 30 days to give you some time to try to hire somebody. If you do get someone hired before the next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to go visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of those you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond and you would have to go back to jail. Do you understand?
Yes.
All right, step in front of the clerk, she'll give you a reset notice. All right, you're Anthony Salvato. Mr. Salvato, you're here on a motion to revoke your probation, and I set a bond in your case. Let's see, I feel like we had received some letters. You were participating in the veterans
Yes.
and all of that.
Yes, ma'am.
You're still doing all of that?
Yes, ma'am.
Good morning.
Good morning.
What is your name for the record?
Catherine Branch.
Okay, and who are you with, Ms. Branch?
Probation.
Okay, thanks. Sorry. And so has he been doing everything with regard to probation? Okay. Have you had an opportunity to try to hire a lawyer?
No, ma'am.
All right. Are you working?
No, ma'am. I've been trying to do the program that we have. I have had a couple of interviews, which I have not been successful because of my record, my health diagnosis. It's been very difficult. I have attended some veteran work job fairs, and that was unsuccessful as well.
Okay.
So, but I have been trying, and I am seeing a employment counselor once a week.
Okay.
Right here the judge is giving Wilkinson the classic proof of effort order. Sounds simple, but it's a legal safety net. If he doesn't try to hire a lawyer, she has every right to raise his bond. Translation: do nothing, go back to jail.
What I'm going to do this morning, Mr. Salvato, and I'm looking back, I have some documentation from the Veterans Association and things like that with regard to when I set your bond. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. You're going to swear under oath that it's all true and correct, and then I'll take a look at it. All right, step in front of the clerk. She'll give you that paperwork. Thanks, Ms. Branch. Sorry, I didn't recognize you. Good morning, you're Daryl Spencer. Mr. Spencer, did you get someone hired?
Mark Kelly,
Did you already hire him?
I was gonna pay him today.
You're okay.
Yes, ma'am. I have money on me right now.
Okay. Did you talk to him about where you were going to meet, or?
I told him about my case and stuff like that. He told me he could make a payment plan with me because I talked to Marcia Borman and she told me she couldn't.
Okay. So you have the money to hire him?
Yes, ma'am.
All right. I'm going to reset your case 2 weeks.
Yes, ma'am.
You need to get him hired before that next court date.
Yes, ma'am.
Right. Step in front of the clerk. She'll give you a reset notice.
Yes, ma'am.
Good morning. Are you Michael White?
Yes, ma'am.
And Mr. White, you are on probation in cause number 23, DCCR 1117, for the third-degree felony offense of driving while intoxicated, third or more. And probation sent an administrative hearing. It looks like as part of your probation, you were ordered to enter and successfully complete the safety program, and that was in order to have a SCRAM device. When you got out of Safety, it looks like you obtained the SCRAM on April 8th, and then they notified probation that you were not meeting your financial obligations, and they terminated that, and so you don't have the SCRAM anymore. Is that correct? So, are you working? Why not? Where have you looked? What different places?
Home Depot Road.
Speak up, please.
Home Depot Road. Different construction company.
Okay. Has he given you notification of all of that?
He has. He also gave me an award letter from Social Security.
Okay.
He received, I think, was it $400?
It's gonna be 220.
220.
He's under review right now.
I can't hear you.
He's under review right now.
Okay. So that was just a partial disability.
Yes, ma'am.
Okay. Well, I guess an option is for him to come to the office more often to take alcohol tests there.
He is coming frequently. He's on a color code where he has to call every morning. And when they call his color, he comes in and does URAs. He also is in the outpatient portion of St. Pete, and they URA him frequently there as well.
But are they also doing alcohol testing?
Yes.
Okay. And everything's going okay with the
Yes, he
outpatient?
hasn't had it.
The only issue is the scram.
Yes, he's going to group meetings and all that.
Do you drive? Okay. So here's what I'm going to do, Mr. White, based on your income and the partial disability, I'm going to retract that order that you have a scram device. I'm going to order that you continue with the drop program, follow all of those rules. Obviously, if you test positive for anything, including alcohol, you'll be right back in here. Also, as of now, a condition of your probation, since you cannot have the scram or can't afford it, is that you do not drive. So you cannot drive any vehicle at all ever without further permission of the court. So if you get to a point where you have the ability to get a car or drive, you're going to have to go through probation, request permission, and then I'll have to take a look at how you're doing and what I can do to make sure that I feel like everybody's safe. Does that make sense? Okay. Anything else you think? All right. All right. Keep doing what you're doing. Thank you, sir. All right, ma'am, you're Ashley Riggins, and Ms. Riggins was previously in court, entered a plea of guilty to unauthorized use of a vehicle in cause number 25 DCCR 0092. The agreement was for 15 months in the state jail prison. We didn't order a pre-sentence report. Is there any reason not to go forward with sentencing today?
No, Your Honor.
And Ms. Riggins, have you gotten into any trouble since your last court date? Okay. Then at this time, I am going to find that you entered that plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody on this case that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Coffin. All right, good luck to you, ma'am. You can go back with the bailiff. Thank you, Ms. Coffin.
This moment is huge at only 18 rows is being told something most defendants ignore. You don't just get a court-appointed attorney, you have to prove you're trying. The judge is basically teaching him adult responsibility in real time.
Good morning. Are you Adrian Housley?
Yes, ma'am.
Mr. Housley was previously in court, entered pleas of guilty or plea of guilty in cause number 25 DCCR 0290 to theft of property with previous convictions. It's a state jail felony. And we pleaded and there were prior offenses, and so the agreement was for a cap of 10 years in the institutional division of the Texas Department of Corrections because of the criminal history before. I received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
Any additions or corrections?
No.
All right, Mr. Walker, you may proceed.
Judge, what I thought was going to be a long argument for us, we're actually in agreement with the PSI report, and we're asking the court to follow the recommendations. and place Mr. Housley on probation.
Mr. Hoffpower?
Judge, we understand in light of what the argument is and the facts of this particular case. However, the court will leave it to the court's discretion. You see his criminal history. He has been in the penitentiary numerous times. So I leave it to the court's discretion whether or not it wants to place this individual on probation or in light of his history.
The underlying, what he ended up pleading to, was it a third or a second?
Second.
Second.
2 to 20 because it's habitual.
That's what I wanted to make, okay,
Yes, sir.
okay.
And Judge, if I may, what we're talking about is over a 4-month span with all the items added up, we're talking about an amount that barely gets over the threshold for a Class B misdemeanor. A 62-year-old Army veteran suffers from PTSD, and as the PSI report shows, he's a low-risk candidate for it. He's not a threat to it. He's went 15 years from his last offense without getting in trouble. He's showing that he's capable of fitting in with society as well as an interest to better himself. And that's why we're going to ask that you put him on probation.
Mr. Housley, on paper, you sure don't look like you deserve probation with your criminal history. Mr. Walker is correct, and the pre-sentence report writer has stated and shown me that it looks like you really are doing well in so many ways. With your history, it just kind of is beyond me, though, that you would go and do something really as minor as what you did, knowing with your history that it doesn't matter how minor it is. At some point, you got to stop, or you just keep staying in prison. Are you still working at Dragon Products?
Yes, ma'am.
You've been, I mean, it looks like you're following through. You following through with your, is it the Veteran Services in Spindletop as well?
Yes, ma'am.
Okay. So here's what I'm going to do, Mr. Housley. I'm going to find that you entered your plea of guilty freely and voluntarily.
Yes, ma'am.
I'm going to find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years.
Yes, ma'am.
And I'm going to order a $500 fine and order that you follow all of the rules and conditions of probation. That will include that you are on the specialized mental health caseload to help with any issues with regard to PTSD and the things that you're going through. You'll be required to follow all of their rules and conditions as well. There's kind of two sides to this, right? And so deferred probation, a lot of times people see and wonder, well, why did they give them that opportunity at not having a conviction on your record when you have all the convictions? And that's for me. It's not for you. Because now that 10-year cap is gone. I didn't send you to prison. So if you do your probation right, then you won't have this conviction. And if you're successful at the end, the case is dismissed and you will be able to continue living your life like you have been, it looks like, for the last 16 years or so.
Yes, ma'am.
The other side of that, though, is if you violate any condition of probation, you're back in court, you're found guilty, which means you have the conviction, and I have the entire range of punishment, which is up to 20 years.
Yes, ma'am.
And on paper, that's what it looks like you will deserve at that point if you don't take advantage of this. So I hope you do. I'm going to hand you the trial court certification that shows this was an agreement I followed, so you waived any right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. Good luck to you, sir.
Yes, ma'am. Thank you. God
Yes,
bless.
sir. Thank you. You too, sir.
Notice the pattern. Every time someone says, "I'll hire them next time," the judge stops believing words and starts looking for action. Court isn't about promises, it's about proof, and Charbino is dangerously close to running out of one more time.
Mr. Nichols, this is Raquel Glover.
Yes, sir.
Sir, are you Raquel Glover? And this is 24 DCCR 0232. Mr. Glover's case is set for trial to begin with jury selection on Monday the 8th. And what is the announcement?
Your Honor, the state has tendered an offer of 5 years in this case. They've also indicated through a notice of enhancement that the punishment range will be a second degree, 2 to 20, because of a federal conviction that Mr. Glover has. He's refusing the 5 years and we're asking you to continue.
So I want to make sure you understand, are you ready?
Yes, Your Honor, state your ready.
And so, Mr. Glover, I will number your case for trial on that date. It's one of the older ones, so you need to be prepared. Talk to Mr. Kimler for trial. I also want to make sure you understand that after today, I will not accept that plea agreement. And so if you change your mind after today, you can enter a plea open to me or to some other agreement, but it's not going to be to that agreement for 5. Do you understand? And you want to go forward with your trial in 2 weeks. All right, stay in touch with Mr. Kimler, and we'll see you back on Monday the 8th.
Thank you, Your Honor.
All right, sir, you're Johnny Polanco Sr.?
Yes, ma'am.
And this is 24 DCCR 2168. Mr. Polanco's case is set for trial to begin with jury selection on Monday, September 8th. And what is the announcement?
I'm ready, Your Honor. This is the one the court will recall. And
It is.
he's not here today. I was mistaken, Mr. Sheriff or Mr. Smith. The other case that he was arrested on was referred to the federal authorities, and there's still been no action on that.
All right, so we'll go forward with this one.
We're ready, Your Honor.
All right, the case will be numbered for trial. Mr. Polanco, stay in touch with Mr. And has there been any change with regard to negotiations or anything like that? All right, so your case will get numbered for trial for the 8th. Stay in touch with Mr. Kimler. He'll know that trial order tomorrow after the docket and let you know when you need to be back. Okay?
This is where courtroom nerves collide with courtroom reality. Forgetting the lawyer names doesn't sound serious until it becomes grounds for jail. The judge isn't being harsh, she's protecting the process. If defendants can't follow tiny steps, big consequences come fast. Now the emotional weight kicks in. A 62-year-old veteran PTSD low-risk report. Legally, this is the perfect example of how context shapes sentencing. Should a decade-old pattern outweigh 15 years of progress? That's the judge's impossible balance. This is the turning point. The judge gives him the maximum chance, but also the maximum warning. One slip and probation becomes 20 years. It's mercy with teeth, the kind that changes lives or destroys them depending on one choice.